incorporate some of those issues already. In that context, we have continually reviewed and we revised, the chief revised the police department's general orders, which are by definition the policies of the Tucson Police Department as promulgated by the chief of police. And I included in your material, both in the memorandum, a summary of the most germane general orders themselves, but we also included the actual full general orders in sections 2300 and 2119 of the GOs. A couple of things that you want to highlight and point out. GO 2300 establishes the overall general policy with respect to immigration, and it emphasizes that all of TPD enforcement activities will be consistent with federal and state law and will protect the civil rights, privileges, and immunities of all persons in the community. 2310 establishes definitions, which are always important sections, but I think in this context especially so, because it addresses issues like probable cause, reasonable suspicion, what constitutes the identification that the officers are going to be examining and that might be provided them in the context of a stop or detention. It also emphasizes that officers in all of their actions must be consistent to avoid even the perception of bias-based policing or racial profiling. GO 2320 addresses lawful stops and detentions, and it is within this general order that the exceptions that I referenced earlier with respect to when inquiries are either impractical or would otherwise obstruct or hinder an investigation, those exceptions are addressed within this subsection of the general orders. This general order also expressly prohibits the consideration of a detainee's race, color, or national origin, except in certain limited circumstances. And it explains how presumptive identification plays in to the officer's responsibilities in the streets, and specifically states that if a detainee provides presumptive identification, no further investigation is necessary into the person's immigration status, absent other facts, such as an admission about the person's status. 2335 sets out the procedures for contacting ICE or Border Patrol. Just one side note on this, because I know I got a question earlier about, well, what does verification mean, or what does a reasonable inquiry require? And under the statute, it specifically requires contacting the federal agency, whether it be ICE, the Border Patrol, or 287G certified. And so the chief has procedures established for making those contacts with ICE and CBP. Some important things here state that the officer, if the officer cannot obtain information from ICE or Border Patrol, then the officer shall release the detainee without delay, period. In the context of if ICE does respond with information, but that the detainee only has federal civil charges, the officer will ask if ICE will respond, but the officer is not allowed to detain the person any longer than necessary to complete the initial reason for the stop or detention, and so will not extend the detention beyond that time frame. GO 2340 applies to arrests, incorporates the language from 1051A with respect to the fact that all arrested, actually 1051B, I believe, all arrested persons have their immigration status verified by ICE CBP prior to release, so that's after an arrest, okay, for a separate criminal offense. The arrest policies are really spelled out in the GOs starting in 2119 and all the subsections thereafter. Those are, again, laid out in the memorandum, but also included in the attachments. They repeat the policy that an officer shall not detain a person longer than necessary to conduct an investigation necessary to complete the original stop, and that if awaiting an ICE CBP response, the arrestee shall only be detained for a reasonable period of time, unable to respond, the person will be cited and released. So in other words, given the ticket and let go. Finally, I want to reference with respect to U visas, the chief has incorporated into his general orders provisions relating to the processing of U visa applications. I think most, if not all of you know that U visas are a mechanism under which victims of crime who assist in the prosecution of crime can obtain a U visa, which allows them to remain in the country legally. It's a visa. Both the chief of the Tucson Police Department and my office, or the city prosecutor's office, facilitate the processing of U visa applications by certifying or not whether the victim has in fact met that threshold of assisting in the prosecution, reporting and prosecution of crime. We attach to your materials the statistics for the processing of U visas, both from my office for the last year and from the chief's office for the last several years. And I know Councilmember Romero, and through her office, and the chief has been participating in regular meetings with folks who are involved in the U visa process to make sure that our procedures are responsive to the needs and concerns that are coming to the fore as part of that. As of course you're all well aware, the Mayor and Council in August 2012 adopted the Immigrant Law of the City resolution. Certain actions have been taken based on that action by the Mayor and Council, including the establishment of the Welcome Tucson web portal, which includes resources and links for all immigrants to access throughout our community. The memorandum concludes, and I will conclude, by noting that based on our analysis that there are some additional actions relating to immigration policies that we believe that we can engage in with the Mayor and Council's direction and support, remain in compliance with the provisions of state law, and yet still carry out the primary objective and policy both of the Mayor and Council and of the Chief of Police, which again are to focus on the prosecution of criminal offenders, to ensure and protect and preserve the safety, overall safety of all members of the community, and protect the constitutional rights of all persons who reside there. Those suggestions are included at the conclusion of the memorandum, and they include as follows: potential revisions to the general orders to further emphasize that in the context of criminal investigations and arrests, that the officer's focus will be on the suspect and arrestee in the investigation of the underlying reason for the stop and detention, as opposed to the immigration status of victims or witnesses. Secondly, that we can state that where the impound of a vehicle in the context of a law enforcement action is discretionary, that the officer will make reasonable attempts to arrange for the transportation of the vehicle rather than having it subject to impound. Thirdly, with respect to the investigation of juvenile offenders, and I included in the memorandum that we're looking at including language that would ensure that when questioning a juvenile, that officers would arrange to have a guardian or attorney present prior to engaging in inquiries regarding their immigration status. I do confess that this is something that we need to look at further, and there are some additional issues with respect to juveniles that we are looking into with respect to transport and other issues, and we may be able to flesh out this recommendation over time, but it is as in the memorandum as of today. I just wanted to note that. Beyond that, outside of suggested revisions to the chief's policies, the general orders, we can always examine examples of what other cities are doing in terms of their immigrant welcoming policies. And Councilmember Romero has brought to my attention some provisions in the Chicago equivalent, their New Americans plan, that really focus on the economic aspect of the economic impact that immigrants bring to the city. And so we can examine those and see if those should be incorporated into your earlier
Thank you, Mr. Mayor. I know we will be getting into the specifics of the general orders and the U-Visa program. I think my question, and I forwarded some of these to you as well, you know, clearly, as Councilmember Romero noted, we anticipated the potentials for SB 1070 to undermine the police department and our community's overall health and well-being and safety. And there is no doubt that if there are, as we believe is becoming more documented, if there are segments of our community, individuals or groups, afraid to call the police because of SB 1070, then victims of crime, witnesses of crime, it basically undermines TPD's legacy and I believe commitment to the model of community policing, where the community participates in public safety. You rely on, I know, people to report crimes, to participate in investigations, all kinds of things. So to me, this mayor and council and our police department, we're charged with keeping the public safe. And yet, when I read SB 1070 and even the dictates in it that still stand, it seems to me what we're looking at is a law which says we must participate to this prescribed degree in federal immigration enforcement, and the increasing knowledge that this law may be in fact undermining the public safety. And so I looked at the charter, and Mr. Rankin, I asked this of you. In the charter, we are specifically charged with enacting regulations that protect the public safety and in essence confront the kinds of things that we believe may be emerging now, and a law that we recognize is prescribed to us by the state. Why would our local authority to protect our residents possibly be able to be usurped by the state law?
And Councilmember Ulick, yes, we are certainly a charter city, and in particular, the city of Tucson has been very protective of its status as a charter city, very aggressive in it. In fact, I think it's fair to say we have established the state law with respect to what the authority of a charter city is. Being a charter city means doesn't mean that we don't have to follow state law. What it means is that on matters of strictly local concern, and we have several instances of those where we prevailed in court. What is a matter of local concern? Local elections, the managing of our individual pieces of property that are proprietary, etc. Where it's a matter of strictly local concern, our charter controls. And so the legislature's attempt to interfere with our carrying out our authority with respect to matters of strictly local